Good afternoon, everybody. I'm Linda Conway. I'm the Executive Director for NENPA, and welcome to day 3 of our virtual sessions, the New England Newspaper Convention. You can place any questions that you have in the chat or raise your hand. We'll be monitoring it the whole time. Please jump in with any questions at any time. So most of you already know Rob Bertsche, but for those who don't, he's a First Amendment and media litigator and counselor, and he's a partner at Klaris. Rob's a former journalist, and he's earned a national reputation representing print and online newspapers, magazines, broadcasters, documentary filmmakers, and websites. He's a longtime general counsel to NENPA, and he also serves on the board of the New England First Amendment Coalition. This morning, he's going to talk with us about how the Supreme Court is changing the law of the press. On to you, Rob.
Thank you very much, Linda. I'm really happy to be here, and I'm excited about this topic. You know, it was only 1964 when the New York Times against Sullivan case was decided, which was the first time the Supreme Court decided that the First Amendment had anything to do with libel law. And it was only about 50 years before that that the Supreme Court really started to apply the First Amendment in general in various speech cases. Even though that First Amendment had been around since 1798. So if that's the case, one might think 50 years now after New York Times against Sullivan, maybe we should not expect that the state of the law then should remain as it has been. And I think now is the time when we're starting to feel those temblors of change. So what I want to do in this session is take a look at where the law is now in 3 different areas and where it might be headed based on a lot of the indications that we're seeing. And in particular, I want to look at 3 different areas. One being defamation, where there's a lobbying on for more protection for public figures. And that would bring with it increased risks for the press. The second area being internet speech, where there's efforts to reduce the immunity that exists for third-party postings on the internet that was established by the Communications Decency Act, Section 230 in 1996, and also for increased oversight of internet platforms. And finally, in the area of copyright and fair use, where the Andy Warhol case went before the Supreme Court earlier this year, with 2 very different notions of what fair use ought to be about, that depending on how the Supreme Court ends up ruling, could change the way we look at that area. And fair use is an area that is of great importance to newspapers, in particular to smaller newspapers that don't necessarily have the wherewithal to be licensing a lot of the work that they may use. So let's plunge right into it and take a look at defamation, where 50 years later, we find the court second-guessing New York Times against Sullivan. I'll start by just refreshing everybody's memory about what libel is and what New York Times against Sullivan did. Libel is a false statement of fact published of and concerning an identifiable living person or company that tends to injure the reputation of that person or company and is published with the required level of fault. And it's that last piece, the level of fault, that is the central issue that we're going to talk about today, and that got not the only thing that the New York Times against Sullivan case changed, but probably the most visible and noteworthy piece that the New York Times against Sullivan case changed. Before New York Times against Sullivan, most states presumed falsity and presumed fault, so that the burden was on the press to show truth and to show a lack of fault. And you can imagine that that changed the picture quite a bit. It's one thing to know that something is true, and it's another thing to be able to prove it to be true to evidentiary standards that can be accepted in court. The New York Times against Sullivan case, you'll recall, came in the context of an ad for fundraising efforts for the Reverend Martin Luther King Jr. And it was an ad run in the New York Times. And in it, it made reference to Commissioner L.B. Sullivan. Actually, it did not make reference to Commissioner Sullivan. It talked about the Southern violators. And Commissioner Sullivan convinced the jury that when it said Southern violators of the Constitution, it was referring to him. Needless to say, this was a jury of his peers in Montgomery, Alabama, who were making that decision. And they also decided that he was defamed by this piece that said that they sang the Star Spangled Banner, when in fact they sang My Country 'Tis of Thee, and that said that they ringed the Alabama State College campus, when in fact the police only went 3/4 of the way around. The issue that came up to the US Supreme Court after there was a $500,000 verdict by that Montgomery, Alabama jury against the New York Times was, to what extent is there going to be protection for a critic of official conduct? In this case, public official, commissioner of the police, who is being criticized for his official conduct. And should it be that easy, essentially, for a crippling libel verdict to be imposed against the New York Times or any other publisher under those circumstances, with just a showing of falsity and not necessarily even negligence? That's the case in which the Supreme Court said, no, the First Amendment has something to do with this. That's news. It was the first time that they said libel, which had traditionally been considered outside of the First Amendment, that libel actually does fall under First Amendment protection to some degree. That level of speech falls under the First Amendment because we need to have the freedom to be able to criticize our government and to speak ill of the government. So they set out in that case and subsequent cases, I'm amalgamating them now, but over the series of cases, the Supreme Court set out a 2-level standard that to prevail, a public official or a public figure has to show what they call actual malice, which it's a horrible term. It doesn't mean malice at all. It doesn't mean spite or ill will. It means reckless disregard for the truth. And I'll say more on that in a second. And private individuals have to show at least negligence on the part of the publisher. In New York, it's more than negligence, it's gross irresponsibility as to matters of public concern. And that's a level that can be set by state law, but it has to be at least negligence. Actual malice, as I say, isn't actually malice. It means the writer knew the statement was false. It's a subjective standard, knew in her mind that the statement was false, or wrote the statement with serious doubts about its truth, with reckless disregard of its truth or falsity. It doesn't mean spite or ill will or malice in the sense that we normally use the term. So this creates a situation where, as you know, when we review pieces, it matters to us, and as we review new cases that come in, it matters to us whether that plaintiff or whether that person we wrote about and wrote maybe some negative things about is a public figure or a private figure. If they are a private figure, it's not that difficult for them to win comparatively, because all they have to show is that we were negligent. The journalist was negligent, didn't live up to the expected standards of a professional reporter in a situation. Whereas if that person is a public official, the commissioner of police, for example, or a public figure, they have to show this reckless disregard for the truth, this much higher standard, which is harder to reach. It requires a showing that the journalist knew that what she was writing was false or had reckless disregard as to whether it was true or false. And here's the reasoning behind that in the New York Times against Sullivan decision. They say, we consider this case against the background of a profound commitment to the principle that debate on public issues should be uninhibited, robust, and wide open, and that it may well include vehement, caustic, and sometimes unpleasantly sharp attacks on government and public officials. And here's the key. Erroneous statement is inevitable in free debate, and it must be protected if the freedoms of expression are to have the breathing space that they need to survive. Take a look at that. It's saying error has to be protected. We're going to make mistakes. And if we don't protect the mistakes, then we're going to be infringing on free speech. In other words, it's so important that we be able to tell the truth about public officials that there's got to be room for error. We've got to have that breathing space to make a mistake now and then, or else we won't get the truth out, because erroneous statement is inevitable. And if you say we're liable every time it turns out to be false, we're going to censor ourselves and go so much short of the line. And that will prevent us, that will inhibit us, and we will not have robust and wide open debate on public issues. That's what we've been living with since 1964. And they said in that case, a rule compelling the critic of official conduct to guarantee the truth of all of his factual assertions, and to do so on the pain of libel judgments that are virtually unlimited in amount, would lead to self-censorship. The constitutional guarantees require, we think, that a federal rule that prohibits a public official from recovering damages for a defamatory falsehood relating to his official conduct, unless he proves that the statement was made with knowledge that it was false or reckless disregard of whether it was false or not. It didn't take long before there were doubts about this standard. In fact, 20 years later, Justice White, who had been with the majority in New York Times against Sullivan, said he's become convinced that the court struck the wrong balance in New York Times against Sullivan. He said criticism and assessment of the performance of public officials and of the government in general aren't served at all by circulating false statements of fact about public officials. On the contrary, erroneous information frustrates these values. In other words, it doesn't help us to allow people to say things that turn out to be erroneous. They're even more disturbed when the statements falsely impugn the honesty of those men and women, and hence lessen the confidence in government. We are undermining the government when we allow people to get away with saying things that turn out to be false about the government. And under the New York Times standard, he says, the lie will often stand because it was not made with actual malice. It was not made with reckless disregard. So the lie will stand and the public will continue to be misinformed about public matters. And how does that serve society, or for that matter, serve the First Amendment? The public then is left to conclude that the challenge statement was true after all, and it leaves the public official without a remedy for the damage to his reputation. Well, you might recognize this fella. When he was running for president, he said he wanted to open up the libel laws so he could sue the press. And he was really picking up on, whether he knew it or not, Justice White's refrain. He says, I'm going to open up our libel laws so when they write purposely negative and horrible and false articles, we can sue them and win lots of money. Because right now we have no chance of winning because the press is totally protected when they criticize public figures. And 2019, we see this headline in the New York Times. Justice Clarence Thomas calls for reconsideration of landmark libel ruling. And in a dissent, he sets out at great length why he thinks New York Times against Sullivan was wrongly decided. And a little while later, 2 justices say the Supreme Court should reconsider the landmark libel ruling. Here's what Justice Thomas said. He says, the New York Times against Sullivan decision was policy-driven, masquerading as constitutional law. He says, we didn't begin meddling in this area until 1964. That was nearly 175 years after the First Amendment was ratified. Apparently, we were able to manage before that, and the states are perfectly capable of striking an acceptable balance between encouraging robust public discourse and providing a meaningful remedy for reputational harm. Now, this may remind you of another precedent from recent years, 1970s, that had been considered by many to be a precedent that was there and not going to be changed, that the Supreme Court has recently said, no, this should be decided by the states. It isn't a matter of federal legislation. And of course, I'm talking about the overturning of Roe against Wade. So we can't rest on our laurels and say New York Times against Sullivan is a solid piece of law that won't change. Justice Thomas is saying, well, look, for 175 years, we didn't have it and we did just fine. And I don't think this experiment since 1964 has worked out very well. One Wall Street Journal article says Sullivan makes society worse because it strips away nearly all of the risk of legal liability for the press when they lie about public figures or issues. Free expression doesn't require protecting lies. Rather, cracking down on lies would leave more room for vigorous public exchange of truthful ideas. And this idea, this theory, has caught on in many circles. You know, what we're doing in this session is really taking a look at the way the law has developed and the way some people are saying it should be developing differently. And you can decide, have we done right so far, or should we be changing route? Intelligent people say we should be changing route. Intelligent people say, no, we've got it right so far, and to change the route would be a very dangerous thing. In Florida, they want to change the route. They've got a House and a Senate version of libel law reform bills, which essentially would come down to the following. They would say that notwithstanding the New York Times against Sullivan rule, that a plaintiff, whether they're a public official, a public figure, or a private figure, they would have to meet the same standard. So there would no longer be this two-tier standard. Everybody would have to prove the same thing. And it would be a whole lot less than reckless disregard for the truth. They'd have to prove any one of the following: that the negative statement about them was fabricated by the defendant, or was the product of his or her imagination, or is based on an unverified anonymous report, or is inherently implausible, such that only a reckless person would have put it into circulation. You look at those words and you can see an awful lot of lawsuits coming out there. How do you define what's inherently implausible and what only a reckless person would put into circulation? Or there are obvious reasons to doubt the veracity of the defamatory statement or the accuracy of an informant's reports, and then it defines what obvious reasons to doubt means, including if it's inherently improbable. And then the House version has one other option that would get you to a win for the plaintiff, which is if the defendant willfully failed to verify the defamatory allegation. Now, you say, well, that's contrary to New York Times against Sullivan, so it can't be the law. Well, here's how it plays out. If Florida passes this law, somebody wins a libel judgment under this law, it gets appealed. The appellate court strikes it down as being contrary to New York Times against Sullivan, and it goes to the Supreme Court. And there, the Supreme Court is faced with the question of, does New York Times against Sullivan is it still constitutionally required, or are we now going to do what Justice Gorsuch and Justice Thomas have asked us to do, which is revisit New York Times against Sullivan and make it easier for public officials to win these cases and put greater risk for the press when they're covering public officials and public figures. Now I'll move on to our next subject. Internet speech and the question of reining in the Wild West. And on this section, I need to give credit to a former associate who worked with me at my former law firm, Michael Lambert, who's now at Haynes and Boone, who recently did a program on this topic. And I called him a few days ago and said, Michael, you did great slides on this topic. Can I borrow some of them? And he said, yes. And so a few of these slides are his or close permutations to his. Now we're talking about internet speech and something a little bit more recent than New York Times against Sullivan, 32 years more recent, in fact, but still 27 years ago. And that is the Section 230 of the Communications Decency Act. And this is the statute that is really considered to have given birth to the modern internet, to have made it possible for the modern internet to grow and thrive. And it's a statute that says that a website or a platform is not going to be liable for comments or postings put on it by third parties. No provider or user of an interactive computer service will be treated as the publisher or speaker of any information that's provided by another information content provider. So to qualify for protection, the defendant has to be the provider or user of an interactive computer service, like a website. The claim has to be treating the defendant as publisher or speaker, suing them for libel over something that is on their website. So it's treating them as the publisher of content on their website that was put there, number 3, by another information content provider, a reader, a poster, any other kind of third party. Second part of Section 230 that's gotten less attention until recently says no provider or user of an interactive computer service shall be held liable on account of any action they voluntarily take to restrict access to material that is obscene or lewd or filthy or excessively violent or otherwise objectionable, whether or not that material is constitutionally protected. It allows the website owner to take down material that they consider objectionable, and certainly material that they consider obscene or filthy or lewd. So it's protecting good faith decisions to block or remove content. And that's used, as you know, by many of the platforms to route out certain voices that may be, for example, advocating terrorism or racist views or violent views. And there are some fringe groups that have said, we don't like that. You are censoring, essentially, a body of speech. And you have the platform, YouTube, Google, have such power such a monopoly really on the avenues of speech that when you block something, you're essentially restricting free speech, because you're almost like the government now. So the liberals and the conservatives alike are finding fault these days with Section 230. From the liberal side, I'm oversimplifying here, but from the liberal side, Section 230 is too broad because it shields technology platforms from responsibility for hate speech or violent content or disinformation that they may host. There had been quite an issue over tech platforms hosting escort ads that were really considered to be, in many cases, ads for child prostitution in disguise, and allegations that the platforms were looking the other way to that. And that has been addressed to some degree by SESTA and FOSTA, two federal statutes dealing with sex trafficking. But there's more. There's a case of Gonzalez against Google that we'll deal with in a second, that asks the question of whether the platforms should be reined in further to hold the platforms responsible for content that they recommend by algorithm. And we'll discuss that in a second. Meanwhile, you can't win. The conservatives are upset about Section 230 for the reason I said before, that it allows platforms to exclude voices on the right from the national conversation and to do so with impunity. And so there are Florida and Texas statutes that are trying to get these states are trying to get the large social media companies prevented from removing posts based on the views that they express. And is that consistent with the First Amendment? And is that something we want society to permit? Let's talk first about the Gonzalez case. This is a case involving the family of a 23-year-old college student who was murdered by ISIS in Paris. And the family sued YouTube for contributing to the attacks. And the reason they sued YouTube is they said that by its algorithm, looking at what this user, this 23-year-old college student, had been looking at and was interested in on the web, YouTube recommended to him, served up to him, ISIS videos, and that led him to be in a position where he was murdered by ISIS. So they were holding or seeking to hold YouTube liable for his murder because essentially they were the link. YouTube was the link between the 23-year-old and ISIS. The federal district court said, no, can't do that because Section 230 protects YouTube's use of algorithms to promote content. Well, it's not simply content put on by a third party, because it was content that was the ISIS videos, was not only put on YouTube by a third party, by ISIS, but it was served up to the 23-year-old by YouTube, in a sense, by the use of those algorithms. And is the use of those algorithms fall under the protection of Section 230? Or is that an active act by YouTube that takes it out of Section 230's protection? The Ninth Circuit took a look at this, and it agreed with the district court that Section 230's protections applied to the algorithm-based claims. The majority said, look, even if Google's algorithms recommend ISIS content to users, they're not treating the ISIS-created content differently than any other third-party created content. and thus are entitled to immunity. That the First Amendment requires that you not favor one kind of content over another kind of content or single it out for punishment. The concurrence isn't very happy about this. It says, I guess you're right. There's no getting around the precedent that seems to say that you're right. But geez, Section 230 really should not apply to activities that promote or recommend content or connect content users to each other. I would read that concurrence as saying, we, the court, aren't supposed to do anything about this, but Congress, will you get on it, please? And the dissent goes further. Section 230 is mutated beyond the specific legal backdrop from which it developed, and I cannot join a majority opinion that seeks to extend this sweeping immunity further. Enough is enough. It goes to the Supreme Court. And oral argument has been held this year, and we do not have a decision yet. So you can make the decision for yourself. Here's what some of the oral argument consisted of. Justice Kavanaugh, there was a lot of worry about this oral argument. There was a lot of worry that Section 230 would fly out the window. What would be the impact on the internet? That the justices would not have, would be reckless in this situation. And I think a lot of observers were surprised by the reticence that the Supreme Court in oral argument showed. You can often read things wrong from oral argument, but here's some of what was said. Justice Kavanaugh says, it seems that you continually, he said this to the advocates, you're trying to focus on the precise issue that was going on in 1996 when they passed Section 230. But the fact is, Congress drafted a broad law, and that law has been unanimously read by courts of appeals over the years to provide protection in this sort of situation. And now you're trying to challenge that consensus. Wow, interesting. Stare decisis. We made a decision years ago. From 1996, we've had this law in place. We've had a body of law develop dependent on it. Why should we change it now? People have relied on that. Well, you may see the irony in that, because this is a court that has not uniformly decided that precedent is to be respected in all respects. Justice Jackson says, look, the statute is narrowly tailored. It's written in such a way to protect internet platforms from claims about failing to block or remove, right? I mean, I thought that's what was happening. And in fact, that is that second prong of Section 230 that says you're allowed to, in good faith, block or remove content, and you won't be held liable for it. Google's lawyer makes this case. And I think it's important, and it goes to the essence of the publishing function, to what you all do for work. She says, all publishing requires organization. She's comparing the algorithm to organization. Helping users to find the proverbial needle in the haystack is an existential necessity on the internet. Search engines, thus, tailor what users see based on what they know about those users. So do Amazon, TripAdvisor, Wikipedia, Yelp, Zillow, and countless video, music, news, job finding, social media, and dating websites. Exposing websites to liability for implicitly recommending third-party content defies the text of Section 230 and threatens today's internet. And Justice Clarence Thomas seems to agree. If you're interested in cooking, you don't want thumbnails on Light Jazz. It's not really recommendations, they're suggestions. They're helpful. They're the only way you can use that bundle of information, the avalanche of information on the internet. Justice Kagan says, well, maybe, but for other products, uh, a razor blade or razor, uh, they have to bear liability when their product is used in a way that causes harm. And they have to internalize that cost of the hazard of their product into the cost of the product and into their development costs, so that they will have a economic motive to minimize that hazard. And she says, I can imagine a world where you're right, that none of this stuff gets protection. Every other industry has to internalize the costs of its conduct. Why is it that the tech industry gets a pass and doesn't have to internalize the costs of its conduct and gets a get out of jail free card, essentially? It's a little bit unclear. And then she says, on the other hand, we're a court. We really don't know about these things. These are not like the 9 greatest experts on the internet. Truer words were never spoken. Justice Kavanaugh, we're not equipped to account for this. Isn't it better to put the burden on Congress to change Section 230, and they can consider the implications and they can make these predictive judgments? I think that's the way the Gonzalez case is going to go, but we'll see. Congress is acting. There are several kinds of bills in Congress to try to reform Section 230, including something called the Earn It Act, which would remove Section 230 immunity for claims relating to advertisement or promotion or solicitation of child sexual abuse material. Now, I mentioned before that states are getting into this act again, and that gets us back to Florida. SB 7072 was signed by Governor DeSantis in April 2021, and it says social media platforms, common carriers, like the telephone, and they have to moderate content in a consistent manner. They, in other words, are now being regulated by the government, like the telephone company. The law would prohibit social media platforms from moderating speech by political candidates. Can't mess with political speech or speech about political campaigns. It would require the platforms to disclose what standards they use to make their decisions, and would authorize the Florida Attorney General and private individuals to bring claims against social media platforms if they violate this law. So now we're going to make the social media platforms accountable to the Attorney General and to the people, and make them be hands off and make them provide certain information. And when that law gets tested and goes to the 11th Circuit, the district court struck it down as unconstitutional. The 11th Circuit says it's mostly unconstitutional too. It says when platforms choose to remove users or posts or to deprioritize content in viewers' feeds or search results, or sanction breaches of their community standards, they're engaging in activity that's protected by the First Amendment, and therefore the government has to keep its hands off. But it did uphold provisions requiring the social media platforms to provide information to users, such as data and moderation rules. And the Supreme Court has been asked to review that decision. Texas, meanwhile, Governor Greg Abbott in September 2021 signed HB 20, which has 2 main sections: one banning social media platforms of a certain size from censoring a user based on the viewpoint of the user, and another section demanding that the social media platforms release information about their algorithms. that case also went up on appeal and then went to the Supreme Court, where the dissent, which opposed the decision to block or to stay the enforcement of the law, said, although they have not formed a definitive view on the novel legal questions, Texas has strong arguments regarding the constitutionality of the law. So you have 3 justices there who are saying, maybe that's allowed. You have Roberts, Sotomayor, Barrett, Kavanaugh, Breyer, 5 who were in the majority, and Justice Kagan dissenting. And now we have Justice Jackson on the court, and she may be a deciding vote with Justice Breyer gone. There are various arguments that the laws are unconstitutional, beginning with the idea that governments dictating content moderation decisions violate the First Amendment, that social media companies, just like newspapers, have a First Amendment right to make editorial decisions, and that these transparency rights are equivalent to telling a newspaper you have to publish certain articles or content, which the Supreme Court has said is unconstitutional. States are also have been implementing age verification laws requiring that users of online services be over a certain age in order to have access. And frankly, I'm not sure how those are being enforced. You'll see the first 2, California and Utah, are not effective until 2024, and the Arkansas is not effective until this September. So I guess maybe they have some time to figure that out. And this slide points out some other social media laws. I'm going to move on from here. So that is the state of play on what we're going to do about social media platforms and the internet. And now I want to take us to a very different area: copyright and fair use, and how best we reward creativity, and the changes that we're looking at here, which are very much in question. A little bit of background. Who owns the copyright for this? This is Naruto. Naruto was encountered by photographer David Slater at an Indonesian national park. Naruto is a 6-year-old macaque monkey, and Naruto picked up Slater's camera and snapped this as a selfie. Photo went viral in 2011. Well, can Slater own the copyright? PETA sues on Naruto's behalf to have the copyright assigned not to Slater, who is claiming it, but to Naruto, the monkey. The US Copyright Office in 2014 says no, he cannot register the work of the monkeys. In 2016, a US judge decides that a monkey cannot own a copyright. I'm kidding you not about this. The whole legal battle pushes Slater into financial ruin, and he considers going into coaching tennis and walking dogs instead of being a professional photographer anymore. Finally, in 2017, he reaches a settlement where he agrees to donate 25% of his future profits to registered charities that are dedicated to protecting the welfare or habitat of Naruto. So the one clear winner here has been Naruto. Monkeys apparently cannot own copyrights, so maybe no one owns this copyright. Maybe this is in the public domain. Maybe the same is true right here. When I went to Dolly the online image generator, and asked it to draw an oil pastel drawing of an annoyed cat in a spaceship. I think I didn't do this. I think somebody else did this, gave it to me. And this beautiful drawing resulted. Oil pastel drawing of an annoyed cat in a spaceship, something we all need to look at. And is that protected by copyright? Who owns the copyright? The image generator or the person who put the prompt into the image generator, or both in some way? Well, the Copyright Office just a couple of weeks ago, 6 weeks ago, issued guidance on this exact question. And it said, consistent with its Mikake ruling for Naruto, that copyright only protects creations made by humans, and that entering a text prompt into an image generator does not qualify as an act of authorship. It's akin to giving instructions to an artist that you hired to do a painting. However, there might be times when the human does have a copyright interest. A human may select or arrange AI-generated material in a way that's sufficiently creative that the resulting work as a whole constitutes an original work of authorship. Or an artist might modify material that was originally generated by AI to such a degree that the modifications meet the standard for copyright protection. And the Copyright Office also put in something that goes with a general trend of saying you've got to disclose AI use whenever it happens, whenever you're using it. And they say in a registration application, a copyright registration application, you have to disclose whether or not AI was used as part of that copyrighted work. You can, by the way, use AI to fight back when you get those nasty letters from plaintiffs' lawyers saying that your newspaper published a photograph that was owned by copyright and taken by and copyrighted by a photographer 12 years ago, and you have to take it down now and pay them $5,000. I went to ChatGPT and said, write a cease and desist letter to a media company that has used the celebrity photographer's photo without permission. Actually, I put this on the other side, but you could do the opposite as well. So this is the letter from the photographer or the media company that is unhappy about the use of the photo. And this is what ChatGPT came up with. It's come to our attention that you've used celebrities' photograph on your website and social media without their permission. This unauthorized use of their work is a clear violation of their copyright rights. We demand you immediately remove it from your website. AI is not a bad place to go for the first demand letter or the first response letter. It's not going to get you much further than that, in my view. And after that, you might have to go to a dreaded lawyer. But you can save yourself some money, at least on the first pass. So the key question when you get to fair use, and that's what I want to focus on now, is, well, it's part of the question of when you can use someone else's copyrighted work. So you know this already. You can use someone else's copyrighted work when it's not creative expression, it's not protected by copyright, it's facts and not expression, idea, not expression. Or the work is in the public domain, like federal government documents, or something that has expired, its copyright term has expired. Or when you have permission from the copyright owner, you have a license, you have oral permission, you have written permission, you have that freelance writer's contract in which they grant you the rights. Or, and this is where we want to focus now, when you're using the work in a way that qualifies as a fair use. Fair use is a very slippery concept. The copyright statute says the fair use of a copyrighted work for purposes such as criticism, comment, news reporting, teaching, scholarship, or research is not an infringement of copyright. So something that otherwise might be an infringement, if it's used for criticism or comment or news reporting, won't be an infringement of copyright if it fits the qualifications that we're about to mention. It's got to be used for criticism, comment, or news reporting. Obviously, that covers most of what you do, news reporting. And those 4 factors, it says in determining, this is what the statute says, in determining whether the use made of a work in any particular case is a fair use, the factors to be considered shall include the purpose and character of the work, the nature of the copyrighted work, the amount and substantiality that you use of the copyrighted work, and the effect of your use upon the potential market for the copyrighted work. So we'll just sort of play those out a little bit because they can be a little bit confusing. Those 4 factors are not additive. You look at those 4 factors and the courts say basically, look at the 4 factors and you put them in a bottle, you shake them up, and you come out with a conclusion. And at various times, different factors will have varying levels of importance. Generally speaking, that first factor, the purpose and character of your use, is going to be a particularly important factor. It's also called or described as whether your use is transformative. Whether, again, you're using it for a different purpose or character than the original copyrighted work. And we'll get into that in more detail. The amount and substantiality of the portion used is also very important. That's why we say if you use less important pieces, that's more likely to be a fair use than not. So then when we look to say, okay, do you own the copyright to the work? No, otherwise we wouldn't be looking at this. You have the copyright holder's permission? No, otherwise we wouldn't have to go to fair use. Is your use for purposes such as criticism, comment, news reporting? Yes, because otherwise it would not qualify for a fair use. Now, is the purpose and character of the use commercial? If it's commercial, that tends towards not being a fair use. If it's non-commercial, that tends toward being a fair use. Are you transforming the work by using it for a new audience or purpose? To the extent that you are doing so, that tends towards being a fair use. To the extent you're not transforming it by using it for a new audience or purpose, it tends to be not a fair use. What is the nature of the underlying work that you are reproducing? If that underlying work is highly creative, it's going to be subject to strong copyright protection, and therefore your using it, your borrowing of it, is going to tend to be not a fair use. That's one factor that will tend against fair use. But if that work is more factual, or perhaps not even subject to copyright protection at all, then you tend towards fair use. If it's not subject to copyright protection at all, it's beyond fair use. It's not copyright infringement. Number 6, did you use the whole work? If you use the whole work, that's going to tend to operate against being fair use. If you use just a small amount, that's going to tend to operate in favor of a finding of fair use. Did you take the heart of the work, the most important piece, will tend towards not fair use? Or did you use a less significant portion that will tend towards fair use? And finally, will your use of the lyric cause the copyright holder to lose money? Your use of the underlying work cause the copyright holder to lose money. For example, will the market for the work dry up? And if that's the case, to the extent that that is the case, that will tilt towards a finding of not fair use. But as you can see, this is very mushy, and lawyers say when they have fair use questions, that fair use is a very, very interesting area of the law. And when lawyers say that something is very interesting, you want to be holding on to your wallet. because the decisions can be all over the place. They can be hard to predict. They can vary based on the judge, and vary based on the time. Let me skip this one in the interest of time. I'm just going to play out one fair use example. Now, this was something that was run, a photo run by BuzzFeed Sports. They ran a picture gallery of the 30 funniest header faces. And this was one of the 30. And they ran it big and on the BuzzFeed webpage. And the photographer of this photo saw it and didn't like it very much because they did it without getting his permission. Was it a fair use? No, they were just saying it's a funny header face. They weren't commenting on it. They weren't doing anything transformative with it. They were using the whole thing. They were certainly cutting into the market for that photo. The photographer could otherwise have gotten some amount of money for it. So clearly not a fair use. What if you credited the photographer when BuzzFeed ran it? Would that make it different? Would that make it okay? No, absolutely not. That crediting the photographer doesn't keep something from being a copyright infringement. So after they got the letter from him, they changed the feature to the 29 funniest header faces and took that one out. But unfortunately, the photographer still sued because they had had that one infringing photo up there for some period of time. And who knows how much he received. And then Ars Technica website decided to write an article about the lawsuit. Headline: BuzzFeed sued for $3.6 million over fairly boring soccer photo. Photographer has no lawyer, but the huge damages create an incentive to sue. And what do? They run that friggin' photo big and big on their homepage. You kind of get the feeling they're giving the finger to that photographer. Can they get away with that? Or is that copyright infringement just like it was when BuzzFeed ran the photo under the 30 funniest header photos? No, they're okay here. Why are they okay? Because now it's a fair use. Now they're commenting on that photo. They're using it in a transformative way. They're using it to discuss this lawsuit about the photo. And that makes it perfectly all right, even though they ran it so big. Maybe more timid hearts would say they ought to run it a little smaller and not tempt fate as much. Me, if I were advising them, I'd say go for it. And I love what they did. So that brings us to the case of Andy Warhol, argued before the Supreme Court several months ago. This case involves the Andy Warhol Foundation and a photographer by the name of Lynn Goldsmith. Vanity Fair was writing a piece on Prince, and they wanted Andy Warhol to do an image of Prince for their magazine to accompany their article on Purple Fame that they called Purple Fame. And as a reference photograph for the article, they went to Lynn Goldsmith, the photographer, and asked her for some photos she had of Prince. And she provided this photo that's on the left. And after she provided that photo that's on the left, Andy Warhol worked it over, and he created that image there that accompanied the Vanity Fair article. All well and good so far. They licensed the Lynn Goldsmith photo, so they had the right to use it. They bought the image from Andy Warhol that he created, so they had the right to use that. All's good. Some years later, after Prince's death, Condé Nast decides to create a commemorative issue called The Genius of Prince. And this time, they decide to use some other Warhol artworks based on Lynn Goldsmith's work. Turns out that back when he did the original work, he did a whole bunch of others. And they held on to them, and they published one of them. And this time, they didn't have Lynn Goldsmith's permission. And they didn't have a license. They had permission from the Warhol Foundation, but they didn't have permission from Lynn Goldsmith. So on the left, you've got the Lynn Goldsmith photo, and on the right, you've got Warhol's rendition of that photo that ran on the commemorative issue. And the question is the photo on the right, is the image on the right, a fair use of the photograph on the left, or is it copyright infringement? Is it a mere copying? Well, when this went to the Southern District of New York, the Southern District of New York said, the district court said it was transformative and a fair use because of the intent and purpose and message being given by that cover, which was showing a Prince of fame as opposed to a Prince of insecurity, which is shown by the photograph on the left. The Second Court of Appeals disagreed and said it's not a fair use, so it went to the Supreme Court. And let's sort of see how this played out. Did Warhol transform Goldsmith's photograph? Well, the US Supreme Court in the Two Live Crew case said a work is transformative if it adds something new with a further purpose or different character, and it alters the first with new expression, meaning, or message. It adds something new with a further purpose or a different character and alters the first with new expression, meaning, or message. Is that what's going on when you compare this to the original over here? New message or meaning over on the cover compared to the photograph? Federal District Court, as I mentioned, says yes, there's a different character in that magazine cover. There is in the Warhol rendering. There is new aesthetics, a different look and feel to the photo. In the Goldsmith photo, it says Prince is a vulnerable, uncomfortable person. And in the Warhol artwork, Prince is an iconic, larger than life figure. Let's look again. Vulnerable on one side, iconic and larger than life on the other, and therefore not mere copying, not copyright infringement. The Second Circuit Court of Appeals, when it's appealed, totally disagrees. Says, look, this isn't the job of a judge. Sort of like Kagan says in in the case we dealt with earlier, in the Gonzalez case. This is just not what courts are supposed to decide. And the Second Circuit Court of Appeals says transformativeness can't be determined based on the stated or perceived intent of the artist, judges, and art critics. The court should decide how the works may reasonably be perceived. And here, the purpose and function of both works was the same. Their purpose and their function was to show what prints looked like, period. Copyright infringement. So, fascinating argument, rollicking argument, goes on for way past, like many of their arguments have this year, goes way past its due time. And the question, Chief Justice Roberts says, seems to be tilting towards saying that this is in fact a fair use. It's not just that Warhol has a different style, it's that unlike Goldsmith's photograph, Warhol sends a message about the depersonalization of modern culture and celebrity status. One of them is a commentary on modern society, the magazine cover. The other is to show what Prince looks like, the photograph. Different people have such different views when they see this. Justice Kagan says in favor of why it is transformative. Why do museums show Andy Warhol? They show Andy Warhol because he was a transformative artist, because he took a bunch of photographs and he made them mean something completely different. That's an interesting argument because it seems to me it ends before it begins. Why do museums show Andy Warhol? Because museums show Andy Warhol, he's transformative, and he's transformative because they show him. Justice Alito, a little more skeptical. How is a court to determine the message or meaning of works of art like a photograph or a painting? Maybe it's not so simple. Justice Barrett is a little hung up on a different question. She's wondering, what about Lynn Goldsmith? I mean, whether it's a fair use or not, he did use her photo as a reference, and he could have used any other photo in the world of Prince. And shouldn't she get something for that? Warhol didn't need Goldsmith's particular photo, right? I mean, it could have been a different photo of Prince. Warhol Foundation argues, and these are the stakes we're talking about here. And these are the stakes that you help decide as we figure out where the law is going. Warhol Foundation's lawyer says a ruling for Goldsmith would strip protection not just from the Prince series, but from countless works of modern and contemporary art. The idea being so much of modern and contemporary art is built upon what came before, borrows from and transforms what was made before by others. Goldsmith's lawyer, kind of responding to what Kagan said before, it's not enough to say Warhol is a creative genius who imbued other people's art with his own distinctive style. Spielberg did the same thing for films and Jimi Hendrix for music, and those giants still needed licenses. And that's an idea. I mean, if Warhol doesn't need a license for him to create something because he's so transformative, why does Spielberg have to get a license when he makes a film from a book, or Jimi Hendrix when he makes music? If you rule for Warhol, copyrights will be at the mercy of copycats, she says. Anyone can take Darth Vader and turn him into a hero, or spin off All in the Family into the Jeffersons, and won't have to pay the creators a dime. So you see catastrophes being predicted by both sides. And we really don't know how it's going to come out. So you ought to stay tuned. Stay tuned to find out how copyright is resolved. Stay tuned to find out how internet liability is resolved. Stay tuned to see whether the New York Times against Sullivan case lasts. And I hope you found this program informative. And if there's time for questions, I'm happy to take any.
Does anybody have any questions? I had one quick question, Rob. So when you were doing the copyright information on the AI images, so anybody can go into AI and create an image and you can use it, like if you don't copyright it, but you can use it in any of your marking material?
Well, that's kind of an open question.
Okay,
Um, there are a number of reasons that it's an open question. One is that AI material has been trained based on a database of material, and the AI isn't creating anything new. It's building on something previous, and that's largely plagiarizing or copying stuff from its trained materials. So the folks whose works are being used as part of that database are increasingly saying, we ought to get a piece of the action. So you've got a problem there. And then even though the Copyright Office has said that its position is that you have that, well, no, you're saying, even though the Copyright Office is saying that humans, nobody has a copyright in AI generated material, there may be a copyright in the prompt or the degree of involvement you had in the creation of the work.
okay, interesting. All right. If there aren't any questions, then I guess we will close out. I thought this was super interesting.
I hope others did as well.
Yeah, I do too.